just for a short introduction, is that on February 23rd, the Commission issued a proposal for a directive on the corporate sustainability due diligence. The whole story of this will be somewhat touched upon in our presentation. If adopted, it will require large companies operating in the EU market to identify, prevent, and mitigate any actual or potential adverse human rights and environmental impact in their own operation, in their subsidiary, and at the level of the established direct or indirect business relationships in the value chain. This is not an unimportant piece of legislation. I think that you can find all kinds of ramification on the face of it. It touches certain areas, but it can be certainly, it may have a broader reach than people anticipate. The way we have had a consultation a few weeks ago, I think about 3 weeks ago, I believe, and now we are in a following that initial consultation, we have presented a few ideas. Based on that discussion, we have now prepared a detailed PowerPoint presentation. We have a report which is ready and in the wings, and we are waiting for that. We're waiting for this session to see what this session brings in, if we need to make any short adjustments. I think prudence requires that we at least, have this presentation and listen to comments from the panelists, but also from the audience. And whether there will be a few changes, probably again there may be changes in the report, but it'll certainly be released either tomorrow or Monday at the latest. We should be issuing this. Again, the way this is going to work, the report has been is the work of Michael Melling, which my colleague, and Ana Ruiz, as well as myself. So we will start with the presentation, and then we'll follow that presentation with reactions from 3 panelists. For Ms. Kuzmanova from E3G, Mr. Vinuealas, who is an assistant to MEP Adrian Vasquez, and thank you very much, Jorge, for joining us today. And last but not least, Evan Williams from the American Chamber. Evan is woken up relatively early. I'm not sure how far he lives from the office, but it is about 8 o'clock in DC right now. I know and have sympathy because I'm supposed to be waking up for a call at 4:30 tomorrow morning with Malaysia, which doesn't fill me with joy. So with this, I will stop here. I think that we have now 5 minutes into the hour. So Michael, Anna, if you will first push the presentation on, and then Michael, you start. We will do a bit of a ballet with Michael starting, and I will do the conclusion to the presentation. So if that is okay, I think it's time, Michael, you take over from here. Go ahead, please.
All right. Thank you, Andre, and thanks, Anna, for sharing the slides. So indeed, a hot topic, I think a very complex one with ramifications that are not fully appreciated by various stakeholders around the world. Unlike, for instance, the CBAM, which you could argue has maybe gotten even disproportionate attention, this one is so complex. And it flies a little bit more under the radar. But the participation even in this webinar, the good number of attendees suggests that it is being noticed. And so we wanted to discuss some of the implications that we see, notwithstanding, the laudable underlying goals, greater sustainability, respect for human rights, etc. It's more the way of doing it that can have both practical consequences that may be inadvertent or unexpected and unintended, or also on matters of principle. And with that, we refer to sort of the broader landscape of principled debate between the EU and its partners around the world. For instance, in the climate space, on the appropriate sharing of burdens and differentiation of obligations, etc. And it's very clear that the corporate supply chain or corporate sustainability due diligence directive will be in a tradition of sort of extending EU visions of what the world should be like onto other countries, even if it's in many indirect ways, not necessarily directly. So let's go to the next slide and just take a step back and look at the context. So it's already apparent that there's been pressure in the public, but even from some companies, to legislate what has been in the past years primarily been occurring on a voluntary basis. A number of large multinational companies, pressured by shareholders, by institutional investors, by consumers and the broader public, adopting a growing set of sort of voluntary commitments on targets, climate commitments, on generally sort of on corporate social responsibility and advocacy, but also including mechanisms that relate to due diligence regarding impacts of their activities across their value chains, both in the countries in which they are headquartered or have established themselves, and in countries around the world. And so a number of countries in the European Union, member states, have begun responding to that, the fact that this is already happening, and there's pressure to try to harmonize and create more legal certainty by adopting legislation. So we have countries like France or Germany implementing their own supply chain or due diligence directives. The UK has laws on slavery. The United States is implementing laws, has a law on forced labor in China, etc. So this is a broader trend that's occurring at the national and regional level. And the idea is that this would help companies, so that's sort of the justification, not only harmonize and create more legal certainty, but it would help companies have clear and sort of transparent obligations with regard to how they identify, prevent, mitigate, and account for adverse impacts across their value chains, whether, again, these are domestic or in other countries, due to companies that they have established business relationships with in their supply chain, so suppliers, for instance. There is an issue, of course, that given this sort of patchwork, growing patchwork of national legislation within the EU and also outside of the EU, there's been no one single definition of what corporate sustainability should be and what due diligence specifically with regard to that sustainability should be. And that has, of course, raised questions and some confusion with stakeholders and companies that stand to be affected by this, but also other stakeholders that potentially are looking for this kind of legislation to help them promote and achieve rights that they feel are violated. And so this has prompted the EU to initiate a discussion about adopting a harmonized legal framework within the EU to avoid such a fragmentation and patchwork within the EU. And if we go to the next slide, so already in several years ago, before the pandemic, the European Commission had commissioned some studies to look at issues of corporate governance, issues of due diligence, and also how to manage impacts across supply chains. And responding to that, but also a request by the European Parliament, the European Commission eventually issued a proposal, which Andrea already mentioned. So this was about a year and a half ago, a legislative proposal for a directive on corporate sustainability due diligence was published. Since then, we've had, of course, the interinstitutional process between Council and Parliament. Early this year in the summer, the European Parliament adopted its positions with some notable proposed changes, and the directive is not yet adopted, so the outcome is expected later this year or early next year, and I'm sure we might hear more about the current state of negotiations from our panel. So let's go to the next slide. As expected, unsurprisingly, this has not been entirely uncontroversial. I argued that it was a little bit, because of its complexity, a little bit under the radar screen compared to other measures like CBAM, which very openly sort of will apply a carbon price to imports from other countries. This is more complex. It relates to corporate sustainability more broadly and due diligence, and it has a number of sort of vague and not so specific obligations in the proposal. For instance, as Andrea already mentioned, it essentially introduces due diligence with respect to the own operations of covered companies, but also with respect to the activities of subsidiaries, and finally of value chain operations carried out by other entities with whom the company has an established business relationship. And it also introduces an obligation for member states to create a framework for liability for violations of the main obligations related to due diligence. And if you look at the definition, for instance, of adverse impacts, adverse environmental or human rights impacts in the provisional definitions, which refers to the annex, you see that it cross-references to a number of international treaties and conventions, both in the human rights realm and also in the environmental realm. And anybody who's worked on international environmental law and human rights law knows that all these obligations tend to be extremely broad, vague and not usually very specific for individual private actors. So there's definitely sort of a very, say, hazy penumbra of what exactly the obligations that are going to come with this directive entail, and where the boundaries are for those directives and for those obligations. And one of the concerns is about the fact that it really extends its reach beyond the European Union. There's been scholarly debate whether it is extraterritorial regulation or not, in the sense that does the EU really go and enforce outside of its territorial jurisdiction? That's of course not the case, but it does very much consider in its, for instance, determination of adverse impacts and whether covered companies have done enough to prevent or remediate them, occurrences outside of the EU. That's the whole point. So across the entire value chain, which could go then all the way to very small companies, very small suppliers, for instance, in developing countries. And there is an expectation, even in the observation from implementation of these national laws, that to some extent, the covered companies will simply delegate the due diligence obligations through contracts to their suppliers around the world. So that's in itself sort of one of the reasons for concern. But there's also more principal concerns, not just on the specifics of implementation and of the exact breadth and boundaries of responsibility that it entails beyond European territorial jurisdiction. More on a principle level, it's also about whether or not this is the EU's prerogative. Again, if you look, for instance, the Paris Agreement, which is referenced in Article 15 of the directive, anybody who works under the Paris Agreement knows that it's all about decentralized determination of the appropriate level of climate ambition, appropriate for the circumstances in the country. It is not something that has been agreed top-down or let alone by one party to the Paris Agreement like the EU. It's up for each country. And so if the Corporate Sustainability Due Diligence Directive has sort of as a de facto knock-on effect that suppliers in countries around the world, including in least developed countries, suddenly are faced with very high expectations in terms of the procedural and material requirements that they have to meet, it is understandable that these countries might argue that that sort of infringes on their right to determine exactly what their domestic companies, what level of climate ambition, for instance, they have to pursue subject to domestic policies. Let's go to the next slide and look at this distinction sort of. So again, there are the practical and operational consequences following from specific obligations, Article 7, Article 8, etc., under the directive. Then the enforcement mechanism, Article 19 and subsequent, including the liability, the mandate for member states to create a framework for liability, civil liability, if obligations are violated under the directive, and all the way to new obligations also for directors regarding due diligence. So those are sort of the more operational ones. But again, as I mentioned, also these kind of fundamental disagreements on principle, whether or not it is the legitimate business, no matter how much one may agree on the objectives, on the goals, the how that the EU is choosing to do this by essentially, you could say, coercing almost suppliers in other countries that may have no choice if the EU is a market they absolutely depend on, and then companies subject to the directive will force essentially these due diligence or delegate, push them down to the suppliers. Let's go to the next slide, please, Anna. So to sort of think of this in the broader context, this is not a new phenomenon. If you know, or if you've sort of read about the growing influence of the EU around the world, there was a nice book a couple of years ago by Anu Bradford at, I think, Columbia University, which coined this term of the Brussels effect. But of course, it's been something that's been known and discussed previously, just not with that catchy title, that the EU has adopted in specific sectors like chemicals, like biofuels, like timber, also product design, even now data regulation, data protection, potentially even in AI. So in many different sectors, there are sort of these policy goals and commitments that have extraterritorial reach, that take into account things that happen in other countries. Say, for instance, biofuels, the life cycle emissions of the production of those biofuels. This is something that's been happening and unfolding for well over a decade already. And now we see it also permeating more and more corporate governance and the mandatory obligations related to corporate governance and corporate sustainability. And if we go to the next slide, we looked at some of the examples of past EU activities that had extraterritorial reach in order to identify whether, what the experiences were with that, whether they were successful, whether they had unintended consequences, and what we may learn from those experiences in anticipation of how the Corporate Sustainability Due Diligence Directive might operate in practice. We started with one that both Andre and I are very well familiar with because we worked on the issues back when it was being discussed, and eventually legislation was adopted that had to be retracted. And that is international aviation, and the proposal to include, and actually legislation adopted to include international aviation in the scope of the European Union's emissions trading system. So flights that depart outside of the EU or that head towards countries outside the EU, the entire emissions from the travel of those flights would have been covered by the ETS. And for those who remember this incident, it sparked phenomenal pushback around the world, both from advanced economy partners like the United States, which even adopted legislation during the Obama administration, signed by President Obama, forbidding US airlines from complying with this directive, including international aviation in the EU, and sparking litigation by US and other international airlines, but also sparking significant diplomatic pushback from China, India, and other advanced emerging economies, which sort of hints at the fact that this is something that can threaten to escalate politically and undermine or erode goodwill in international cooperation. Now, 2023 is not a year where we would say there's tremendous goodwill in international diplomacy anywhere, but that may make it all the more important to sort of tread cautiously when introducing obligations that could rub important partners around the world the wrong way. Now, sustainability of timber, biofuels, I already mentioned that, and they're in operation. They have, by and large, worked. There's been some sort of unintended consequences. The whole promotion of biofuels under the Renewable Energy Directive could be said to be sort of a chain of unanticipated consequences that required revisions and corrections. But there's at least less sort of striking takeaways from that, except that it has been implemented and is having an effect in those markets, which suggests that the Corporate Sustainability Due Diligence Directive likewise would have a significant impact. It wouldn't be something that's trivial, given that foreign suppliers, et cetera, take these things seriously, have to take them seriously to avoid consequences. REACH on chemical safety. So the regulation that was introduced, gosh, it's already over 20 years ago, that pretty much creates a Europe-wide, very stringent framework for the notification, authorization of chemicals, and requires all foreign producers of chemicals to abide with those same rules. Again, very controversial, elicited a lot of pushback, but also has sparked emulation, sort of following of the model by many other jurisdictions. So again, it had a definitive impact, but it also resulted in some frictions in international negotiations, in international cooperation with partners. And finally, of course, the CBAM, just implemented too early to really say what the implications will be, but we can already say from news reports and conversations with policymakers in other countries, et cetera, that this is taken very seriously, but also is controversial from the US and policymakers in the US to China, India, and elsewhere. There's been a lot of pushback, threats by India to litigate before the WTO, for instance. Also, a lot of conversations on how exactly it will be implemented and what it means for these other countries. So again, the impacts are quite clear, and also the fact that it's not terribly popular and it can potentially lead to some disagreements between or in established relationships. A good example, most recently, the EU-US the Global Arrangement of Sustainable Aluminum, Steel and Aluminum, which more or less collapsed over disagreement exactly on the shape of something similar, just for those two sectors and between the EU and US, showing how difficult it is to get sort of agreement across the board. And finally, there's also some concern that there are weak points in the CBAM as set out, as adopted, for instance, with regards to exports leakage, circumvention, indirect emissions, and other aspects. So a lot of probably continued learning by doing to make sure that loopholes and frictions don't undermine the effectiveness of that regulation. So a mixed picture from the past application and implementation of existing EU legislation and policies with extraterritorial reach that at least cautions us. It doesn't say that it's doomed to fail, but it does caution us that there can be unintended consequences, including political consequences that should be taken seriously. If we go to the next slide, so Anna's done a great job in the report and going through sort of the various member state laws on due diligence for supply chains, for forced labor, slavery, etc. Also rules in other jurisdictions like the UK and the United States. And the picture that arises is that there's still a lot of heterogeneity, which partly explains why the EU is eager to sort of try and harmonize this within the EU. Different definitions, different approaches. One interesting takeaway is that in France, it's already causally resulted in a growing number of growing litigation. So that is something that one has to probably expect also from the CSDDD, given Article 22. Also, the German example, where we heard stakeholders in Germany telling us that very clearly large, purchasers of foreign, large companies that are subject to this law are simply including clauses in their contracts that more or less indemnify them and shift the burden of complying with this law to suppliers in third countries. So that is kind of not necessarily circumvention, but maybe an unintended effect that one also has to be cautious regarding the implementation of the CSDDD. Let's go to the next slide. I want to get to sort of our takeaways and conclusions. So it's without question, this is very broad. I already mentioned some of the concerns about the breadth of the scope, even though it's differentiated between companies that are established according to EU law versus companies that are established under the laws of third countries. The thresholds would differ, but still a not trivial number of foreign companies that do business in Europe will be affected by this. And perhaps most importantly, suppliers in developing countries that may lack the capabilities and the technical resources and the financial resources to fully comply, especially if these obligations are simply kind of rolled over to them. And the Commission acknowledges that in the proposal, saying that this is something of concern, but it will ensure that there are mechanisms in place to help small and medium enterprises, medium-sized enterprises, suppliers in third countries and especially in developing countries to comply. But it's not clear exactly what that support will look like. Anyway, there is recognition that there could be sort of unequal or inequitable impacts on companies outside of the EU in particular. The cross-reference to environmental and human rights treaties that opens up a very broad sort of scope of interpretation of exactly what the obligations under those treaties are specifically for companies, which typically international treaties never have obligations specifically for companies. It's only through the implementation by the parties to those treaties. So again, concerned about the scope and the uncertainties there. Some aspects on implementation, how this will create a uniform compliance and enforcement monitoring framework, if you like, across the EU. So we don't have to go into, and I've mentioned some of these things already in detail. So that's especially how the directive as proposed would kind of differ and build on what's already in place in some member states. And without question, I think the German Lieferketten-Sorgfaltspflichtengesetz, for instance, will become, it'll have to be amended, but it would become the implementing act for the corporate sustainability due diligence directive, likewise the French Loi de Vigilance. But many member states do not yet have any such acts, and probably some would never have adopted such acts. So this does also change the landscape for them. Let's go to the next slide. I think I'm coming to the point soon where I will hand over to Andre. So without disputing sort of the underlying high-level objectives, of increasing sustainability, we all agree the goals of the Paris Agreement, etc. I mean, there's no debate there necessarily, nor on the need to try and respect human rights per se on principle. The way in which this will be implemented and the scope and breadth, but also the uncertainty of obligations, will without question incur costs. And there could be disproportionate impacts on certain companies and also in certain countries that would not be necessarily what is intended or what should be the goal of this directive. Clearly, with Article 19, 20, 22, the liabilities and increased litigation risk is something to take seriously. for many, many years, since the 90s, we've had this sort of efforts under the Aarhus Convention and other instruments to expand access to justice and legal standing to civil society, to other stakeholders. But this goes even a step beyond that, that individuals that are not necessarily themselves affected can, for instance, under Article 19, register concerns and initiate sort of enforcement processes. And the exact scope and boundaries of that are not entirely clear yet. The Commission assumes that this is bounded, sufficiently bounded not to result in runaway concerns, but other stakeholders have clearly voiced concern that this could open the doors to a floodgate, for instance, in litigation. And again, observation or anecdotal evidence, say from France, suggests that that may indeed be the case. We're just at the very beginning of this game. Again, the room for interpretation, concepts like adverse impacts, the cross-references to treaties, etc., that of course results in legal risk. Legal risk means that companies will have to hire counsel and set up sort of procedures and processes to deal with the legal risk. That in turn results in higher costs, and those costs will accrue somewhere. And it could even potentially result in conflicts with obligations in third country legal systems, given that we are unlikely to have a globally harmonized system. And finally, it's unclear and hard to predict, and I didn't see quantitative, attempts to estimate through CGE modeling or so how the CSDDD, and it'd be very, very difficult to do so, may affect trade flows around the world and where countries invest and where countries might switch suppliers because suppliers in some countries are no longer considered reliable or too risky because of the lax rules in place in those countries, or because they simply don't have the capacity to ensure that they meet what the covered companies will require from them, given the obligations along the value chain. So this could potentially result in barriers for market entry and also especially market access for suppliers in developing countries. And here I think it is the last one, the next one from my side. So without question, this is yet another step in sort of the, especially in recent years, very manifest push of the EU to increase the standard of sustainability, both with regards to environment, but also human rights, that has been moving on so many different fronts: sustainable finance, Fit for 55, et cetera, generally the European Green Deal. But there is definitely also a risk that, like some of these other instruments, it may make doing business in Europe harder, which can shape the competitive landscape, especially if other jurisdictions around the world do not follow suit. It could result in making the EU a less attractive place for business. And finally, especially in those high impact sectors like textiles, agriculture, etc., those would be particularly vulnerable. And it's too early really to anticipate what the exact impacts would be, partly also given the difficulty of trying to model that in any robust way. With my voice almost gone, I think I can hand over to Andre. Andre, unmute.
I am mute after all these years. I've never learned. Cannot teach an old dog. But anyway, look, these conclusions and recommendations. I'll take you through a few slides that will kind of give you the takeaways that we think we can put forward from this. First and foremost, I mean, to me, look, we are a think tank, and therefore, presumably, we think great thoughts. If that is the case, then I think we have to divide these things, the whole debate into practicalities, but also matter of principle, because principles matter. We tend to have forgotten this thing over discussions over the last number of years, avalanche of papers, avalanche of proposals. A lot of principles kind of, let's do this because this is an emergency. And what are the principles? Well, we'll deal with the principle later. But I think that principles matter. And this is why I would say, the first thing that I would say is that this is not a minor thing. It is a pivotal development in the political and regulatory landscape. And at the heart of it, I would argue that one of the main arguments is the fact that you're trying to make sure that people do the right thing, and there's no out of jail escape card, but also the establishment of a uniform standard for corporate supply chain due diligence. Now, Michael has taken you to all kind of arguments, some of them more legal, some of them are policy. Now, to my surprise, I read something that was unexpected to me, and I'll read it to you because it comes from the think tank of the EU Parliament website. What it says is several companies have announced that they are ending their dealings with Iran unless a way can be found to exempt or shield them from US secondary sanctions. In response, the Commission adopted the Delegated Act on June 6, 2018 to update the annex to blocking regulation, which was adopted in 1996 to protect EU businesses against the effects of extraterritorial application legislation adopted by third party. The blocking regulation forbids EU persons from complying with extraterritorial sanctions, allowing companies to recover damages, etc., etc. Now, I'm considering that the U.S. had a legislation. Now, it came to a surprise to me. Frankly, this is not my field. International security is not my field, but nevertheless, just Googling it, you end up with something like this, which has to raise some issues. So, the fact of the matter is, so again, the second point is issues of principle and on practical operations. There is the fundamental principle of national sovereignty on the UN Charter. We do not have a global governance. We do not have a global government, at least at this point. And as such, the nations are still sovereign under the UN Charter. The other thing is, I learned this from the person that I worked for, who was the Secretary General of the Rio Conference of '92, so a person with some knowledge, who always told me, Andre, sustainable development definition is a national prerogative under the Rio Convention. This is the guy who wrote the Rio Convention, so I would assume he knew what he was talking about. Next slide, please. Now, I think that if that is the case, now going to practicalities, because all the flip-flops become practicalities and principle, the design of a CSDDD and implementation should be sensitive to the different capacity and scale of businesses, especially small and medium size. In many cases, we pay lip service to that, but then in the end, yes, they find themselves as at the end, receiving end of yet another legislation. I am running not a small business, but a think tank, which you could argue is a small business, but I cannot imagine a real business kind of dealing with all the legislation and the formalities that they have to do. Now, on the issue of civil liabilities, they exist currently. They are placed in national legislation. There's one thing that I learned. I negotiate under the UNFCCC, and under markets under the UNFCCC, the CDM, and in the CDM was something that was introduced, an appeals process, because the CDM was a very unique instrument that had legislative, a regulatory instrument market that didn't have an appeal process. So somebody had a brilliant idea in Copenhagen to introduce an appeal process. You know what? It's been on the books since Copenhagen. And we always meet and we say, so what do we do now, guys? Okay, we punt it to the next COP because we won't agree. Why don't we agree? Because what we could never agree, the G77 and China could never agree as to who can appeal on this and what do they appeal on. So if you should you maintain something like this in the CSDD, even though they exist in national legislation, I think we have to be very careful who can have access and make use to such an instrument, because allowing intervention to anybody everywhere in the world, that is a recipe for gridlock and a recipe for essentially having a lot of things being blocked. Now, the other thing, Michael has spoken to this, decision makers should also be mindful of potential impacts on the attractiveness of Europe as a competitive location business activities. Look, if I am a company from, I don't know what it is, Rio de Janeiro or Mexico City or Santiago de Chile, and I want to open a sucursal, a subsidiary in the EU, if all of a sudden all my operations in Latin America are subject to this, I must really have a good business case to do business in Europe, or else I'm going to get into a lot of stuff for all my operations around the world. Next, please. Now, the one thing that again, I don't run a business, but I think it's kind of a logical statement that you should really wonder whether companies can be made responsible for value chain under which they have no reasonable control. There are some over which you have control. I mean, we look at many cases. When I was younger and working in the UN, I remember we dealt with H&M and a number of other companies that have supply chain problems, Adidas and so on. But there are some that are more reasonable than others. In some cases, simply don't have control over this. We mentioned the fact of a Fundamentals Act that companies could face liability for action of business partners that occurs throughout the world. The fact that multinational companies operating in the EU may confront multiple overlapping obligation due to due diligence obligation outside the EU. Now, the CSDDD is having an impact, and I did negotiate part of the Paris Agreement of turning obligations by member state under the Paris Agreement in obligation for individual companies, both domestically and internationally. When we negotiated Paris, it's a party-driven and party-related process. It was never intended to. That was not in the intention of the Paris Agreement. The Paris Agreement in general, it is a global net zero. It is not individual net zero in every hamlet of the EU and of Thailand. So I think that kind of putting this net zero or every obligation of the Paris Agreement, I question whether that was the intention and what people signed on in Paris. Next, please. The other, one issue, it may be that there may be EU legislation that clashes with legislation, local legislation. We saw some of the blocking acts. Michael addressed some of the U.S. acts that forbid people to observe the ETS. Now, there is also the issue that we're looking at it from the point of view of the EU. If you look at it from the point of view of developing countries, because most of these operations will be in developing countries, I have learned that sustainable development is a national prerogative. Now, this can make sustainable development become to be seen as a tool of developing countries. This is not a joke. Again, we took it for many years that sustainable, then that was a mantra that sustainable development is the prerogative, definition of it, the prerogative of a national jurisdiction. The moment you start doing something like this, I think it's becoming an issue. I do remember in the CDM, where we're negotiating CDM under an FCCC, there was the sustainable development tool that some parties wanted to impose. And I remember Brazil, I remember a number of other countries kind of say, wait a second, they were using some very, very harsh words that I don't think is my right place for me to repeat this, but there were certainly concerns about that. It also may, as I mentioned, infringes of national sovereignty of developing another country risking counteraction, and this was mentioned. Now, the last thing is that the Paris Agreement is a party-based agreement based on NDCs, which are nationally determined. And the EU, I would say, could be seen as undermining this fundamental building block of the Paris Agreement. I know this is controversial, but I also think that the NDCs are nationally determined, were determined in Paris as being something nationally determined, and moving away from that into another domain, whether it's a CBAM or something else, is something that is questionable. I think this is the last slide, Anna, isn't? Yeah, this is the last slide. The last slide is thank you very much, and ERCSD. And now it's time for Michael and Anna and myself to sit and wait to be kind of beaten to a pulp. But this is what people do. Intellectuals, we have intellectual conversations and we listen to criticism. And it's a fair game as long as it's civilized and doesn't degenerate into name calling. So, Tsvetelina, you go first. I'm sure that you will not agree with a lot of things, but this is what we invited you. But this is why we invited you here, because we want to hear the critical voice.
Thank you very much. Thank you very much, Andrei. Can you hear me well?
We can hear you very well, and thank you very much for taking the time.
And thank you for passing on to me for the critical voice. I have to say that Michael, Andre, and Anna, this is an incredible work that you have done, very comprehensive. But I will indeed be critical to some of your comments. And within my comments, I'll also try to provide some updates on the latest developments within Brussels and the negotiations on this file, because I think this will be also interesting for people here on the call. First of all, on the extraterritoriality and the EU prerogative, I just wanted to say that in itself, it goes both ways. And within financial regulation, this is not a novel idea. And I was actually recently reminded of the Faulkner rule in the US in the aftermath of the financial crisis, and how banks were prevented from making certain investments. And it had massive repercussions around the world, including within the EU. So within financial regulation, I just wanted to start with reminding everyone that these rules are not a competition of who can impose more rules on other jurisdictions, but the basic idea is consumer protection, financial stability, or in the case of the CSDDD, human rights and environmental protection. So with that in mind, just wanted to say that these rules are created and are being crafted with a different, not necessarily within the competing notion of who can impose more rules on the other jurisdiction. And that being said, within the scope of environmental protection, the Paris Agreement, and because you mentioned Rio as well, things are changing, things are very dynamic and are changing very quickly. So within this, also the rules and regulations need to be adapted as well. I was also recently reminded by a US colleague of mine about the California effect, because Michael, I see that on the list of different rules, you were also mentioning one of the recent climate disclosure bills. I think there are two climate disclosure bills in California, and there are anticipated ripple effects within the US, different parts of the US, but also outside of the country as well. So with this, I just wanted to remind everyone that this is the direction of travel, not only within the EU, but in other jurisdictions as well. And the rules, it was mentioned in the beginning of your research that a lot of companies are already doing this on a voluntary basis. So the rules and regulations on that front, at least in the EU and different pockets in the world, even within the US, are following the market trends. With this, obviously, as I mentioned, the rules are being drafted for consumer and stakeholder protection perspective, but also for the benefit of the company. So I wanted to come back a little bit to what this means for businesses, and in the end to go back to your competitiveness, what this will mean for companies in different jurisdictions' competitiveness in the EU. A couple of days ago, the European Central Bank, Frank Elderson, actually made some remarks explicitly calling for the financial sector to be included in the Corporate Sustainability Due Diligence Directive. Just as a reference for the moment, this is an interinstitutional negotiation process almost coming to an end. We have one trialogue later this month, and possibly another one in December. But for now, the biggest question is what role the financial sector will play, whether the financial sector will be within the scope of the due diligence directive. So with that in mind, this is the hottest topic at the moment, the most negotiated topic. But even within the European Central Bank, there were calls for specifically including the financial sector from a risk and very specifically from a risk management perspective. And here I just wanted to mention a couple of considerations why this is important for European businesses and financial sector market players who do business within Europe as well. Why this is important for those companies as well. So as I mentioned, the risk evaluation, the measurement of the impact and management of those risks is increasingly important for companies to understand the climate risk, but also what it will mean for the long-term economic repercussions. And that links to the market trends and policy trends and the risks associated with it. For example, if there would be in the longer term, any additional carbon taxes or any additional, how this will affect their costs. Michael, you mentioned some of the most vulnerable sectors that would be within the scope of this legislation, like agriculture. I think you mentioned a couple of others as well. But these are also the most exposed to climate risks sectors as well, and would potentially be the most affected price-wise when it comes to other specific sectoral legislation. So from this perspective, the legislation itself is important to also take into account and address those types of risks. Most recently, the EU also finalized the so-called European Single Access Point. So I wanted to mention the reputational risks and what this means for companies, and such initiatives are emerging on a more voluntary basis globally as well, with for instance, the Bloomberg Net Zero public data utility. But this is sort of the direction of travel of more public-facing disclosure of a lot of that information. Within the EU, it will be mandatory, but in other parts of the world for other companies, it is also emerging. So from a reputational risk, and to come back to the legal risks as well that were mentioned, a couple of weeks ago, the whole Dutch financial sector, including the pension funds, the insurers, the banks, the whole financial sector signed a letter explicitly in defense of the CSDDD from a legal risk perspective, and what will this mean for the sector. Exactly around the points that Michael, you were mentioning about the broad and not so specific, not specific enough regulation can expose the companies to additional litigation risks. So from that perspective, the financial sector, the whole financial sector of the Netherlands called for more clarification and more specificities for the financial sector to be specifically included there. So these are some of the risks I wanted to mention. Finally, I'll come back to the competitiveness. I think you have done a good job outlining some of the most immediate short-term consequences and the implications for competitiveness of European businesses and third country companies as well. But I think it is also important to really, within all these points that I made, to also consider the short-term financial burden, litigation costs, and the compliance costs associated with also the long-term competitiveness of the businesses and the long-term opportunities, which I don't think have been that well examined yet and assessed. And here what I mean is that a lot of this legislation and within the EU, the corporate reporting and the corporate due diligence, the corporate rules that are emerging in Europe and globally are really within with the idea in mind to support the business transformation and adapting the business models of those companies for the long-term transition and the transition of those businesses. And with this comes access to more diverse capital, diversified finance, and access to, for instance, public subsidies. Now we have in the US the Inflation Reduction Act, and in the EU the response with the Net Zero Industry Act and GDIP. So with this comes also a lot of longer-term competitiveness benefits and access to more diversified finance, I have to say. And for a third country, maybe finally ending on that point, I just remembered that you mentioned in the end, Andre, the third-party companies in third countries. In the end, a lot of the whole idea behind this legislation is also to really safeguard the stakeholders and the human rights and the environmental protection in that country, in those countries, precisely to ensure that European businesses are not pushing down the line those negative practices for other jurisdictions and to make it their own problem. So in the end, all in all, a lot of the issues we discuss here are very national in scope, as you mentioned, but in the end of the day, environmental protection and human rights are increasingly global. Yeah, to end on the overarching idea behind the legislation. Thank you.
Thank you. No, I appreciate very much. I mean, we are very much appreciate the comment. I mean, this is what that's why we're a think tank. We need to hear the diversity of views, and we certainly heard a very well argumented point of view, and we'll come back to that and really appreciate it. Jorge, thank you very much for joining us today.
Thank you, Andre, and thank you to the organization, to the European Roundtable on Climate Change and Sustainable Transition for having me, and first of all for organizing this roundtable. This panel. We in the European Parliament have been experiencing for already a while the difficulties arising from this very complex file, and any kind of input from think tanks, civil society has been and will continue to be paramount to conduct the negotiations, hopefully to be concluded still in this mandate. So, I mean, I would like to start this intervention by giving a little bit of context before jumping into the key elements of the report, or at least into the elements of the report that I have found as more relevant ones in light of our experience in the negotiations. This context I wanted to describe starts with the fact that this is an exceptional file that has raised an unprecedented level of attention. Maybe unprecedented is too much, but a high level of attention within the institutions. We all know that already in the preparation phase in the European Commission, there were already some troubles. This was a directive that received 2 negative opinions from the Regulatory Scrutiny Board, and that, let's say, veto had to be waived by the College of Commissioners, because this was and still is one of the priorities of the Green Deal. This, in our view, already shows that there are a lot of elements of this file that needed to be discussed, that needed to be carefully crafted, so that the provisions of the Due Diligence Directive are doable and reasonable for companies, and that also meet the expectations that everybody's putting on it. So that's what we've been doing in the European Parliament since the beginning. Also in the European Parliament, by the way, this created a lot of interest. We had 13 committees out of 20 requesting to provide the jury committee, the leading committee, with an opinion. Eventually, we have only seven committees providing with opinion. So this is to show or to give some example of why this dossier is gathering so many inputs, and there are so many relevant players in the legislative process that are trying to shape the content of the file. Now, this being said, after giving this context, this general picture on the interest raised by the file, I would, as I said, jump into some of the elements of the report that I've seen as more relevant or more decisive for the continuation of the negotiation here. The report focuses on the need to prevent an excessive burden on European companies, and particularly if this burden, coming from the obligations of the due diligence directive, has the potential to create a disadvantage between the European companies, the EU companies, and their competitors, mainly in China and in the United States. We have been aware of this since the beginning, and I have to admit that negotiations have been very tough in order to find ways to prevent as much as possible these competitive disadvantages. First of all, we had to prevent this competitive disadvantage to happen within the European soil, within our own borders. And this is because the proposal coming from the Commission set different thresholds for EU and non-EU company to be covered by the directive when operating within the European Union. That to us was not acceptable. When I say us, I say the European Parliament, because we have indeed changed this in the position of the European Parliament. And what the Parliament is proposing here is to put the same thresholds, at least when it comes to turnover of companies, that would be required to have to apply the directive. Of course, when it comes to non-EU companies, it is necessary that at least part of this turnover is generated in the EU to be compliant with the WTO rules. But still, we are really pushing for that specific element to try to achieve a level playing field between EU and non-EU companies. First of all, in the European soil. So we pretty much share that concern. Then, when it comes to out of our borders, I think the previous speakers already mentioned it. Of course, when operating outside the EU, the European companies will find themselves in some difficulties when dealing with providers, and when asking those providers in the supply chain to fulfill with the due diligence obligations or to be due diligence compliant. Because other, let's say, worldwide companies from China or United States or other countries will not have to request that from their clients or providers. So of course, to some extent, those difficulties cannot be prevented, and that is something that is very important to take in mind, to keep in mind. If we are fostering this directive, and we all agree that, I think we all agree that some kind of due diligence directive at European level is necessary, but part of the cost of having this kind of legislation in the EU and for EU companies, even when operating outside the EU, is that totally preventing those differences with non-EU companies will not be possible. But still, what we can do, and as a European Union, as a legislator, and at least what we are trying to do in the European Parliament, and I think also the Council is in this line, is to have a text that is as feasible, as reasonable, and as OECD aligned as possible. When I say this, it's because many of the main companies that will have to apply due diligence in the future are already operating on the basis of some kind of due diligence or corporate responsibility, mainly within the framework of the OECD guidelines, and we have already discussed risk-based approach for the due diligence. So we are trying to really introduce those elements: the risk-based approach, the leverage as a prerequisite to comply with due diligence in the text. We think that by doing so, we can at least make the directive feasible and reasonable for companies operating outside, and reducing that potential competitive disadvantage with other companies. Then, last but not least, we are also trying, and this is more a Renew Europe thing, you know, I'm representing a Renew Europe member of the Parliament, to narrow the civil liability regime in such a way that entities that are able to file lawsuits against companies for breaching in due diligence obligation is limited to those entities that are actually representing real victims of adverse impacts, in a way that not any entity whatsoever around the world is able to come to the EU, to an EU Court of Justice, and file a lawsuit against an EU company for something that happened outside our borders. So we are trying to craft and to refine the civil liability regime to ensure that this doesn't become a source of excessive litigation. Then a second element that I would like to outline from the report is the importance of preserving the single market and avoiding fragmentation, regulatory fragmentation within the EU. This is paramount, absolutely paramount in this legislation, because as it was already mentioned in previous interventions, some countries already have their own law. It's the case for Germany and France, and others were already working in some kind of due diligence legislation. The Netherlands is an example of it, or Spain, my home country, was already doing a public consultation so that the country could have in the future its own due diligence obligation. So indeed, preserving the single market and some kind of harmonization is in the core of this directive. However, we regret to say that some relevant opportunities have been missed here. The first missing opportunity to avoid fragmentation, regulatory fragmentation in the EU, is that we could have had a regulation instead of a directive. With other relevant pieces of legislation in this mandate, we have seen how the Commission has fostered regulations instead of directives. Is the case for the Artificial Intelligence Act, for example, where if the EU really wanted to have an harmonized approach to this, a regulation would have been the tool. However, this was not the case, and as I said, that's already a missed opportunity. So we have to work with other options. We have a second almost missed opportunity, hope not completely, but that was the introduction of some kind of single market clause or full harmonization clause in the directive. Both Renew Europe and, I have to say, also the EPP group in the internal negotiations in the European Parliament really pushed to have this kind of provision, if not over the entire directive, to have the entire directive fully harmonized, at least in the core articles of the directive, definitions and the due diligence procedure, articles 5 to 8. That was not possible in the European Parliament due to the lack of a parliamentary majority behind that claim. In other words, well, the group of the rapporteur and other groups were not in favor of any kind, basically any kind of full harmonization, not even for a few key articles of the directive. So unfortunately, that is not part of the position of the European Parliament. And what is more surprising, or maybe not that much, is that the Council does not have any kind of a maximum harmonization clause in their general approach. It is true that the Council has been trying to moderate some provisions of the directive and to make it more feasible for particularly for companies and for industry. But when it comes to maximum harmonization, we have to say, and we have to admit here, that the Council is maybe not leading by example, as far as they not only have renounced to include a maximum harmonization clause, but also in such a relevant provision as the inclusion of the financial sector in the scope of the directive. The Council has included an opt-in clause. So basically, that's exactly the opposite to maximum harmonization. If any country, if all the countries of the EU, if all the member states are entitled to decide voluntarily whether or not the financial sector will have to comply with the due diligence obligation in their own territory, I mean, that's I think we can all agree that that's pretty much the end of the attempt to prevent fragmentation. What's left then after these two, one missed opportunity and one almost missed opportunity? Well, basically what's left on the table is trying to be as detailed as possible when regulating the provisions of this directive, and particularly articles 5 to 8 and definitions. And that's what we are trying to do now in the final stage of the negotiations. We are trying to really have definitions and a description of the due diligence process and appropriate measures to be taken by companies under due diligence as detailed as possible, so that when transposing the directive, there is a little margin of maneuver. And of course, we don't find ourselves in a scenario where obligations end up by being completely different in every member state. I will finish with a third element that I really consider paramount in the report, which is the need to have a thoughtful and balanced implementation of the directive in the future. Once that we adopt the directive, to have an implementation that is as good as possible. To this aim, in our opinion, it is paramount, first of all, that the European Union keeps in mind that there will be already this due diligence directive when presenting new initiatives, sectorial initiatives that already also include due diligence obligations. This is the case, for example, with the forced labor directive and with other pieces of legislation that may come in the future for specific sectors. So it's very important to us that these pieces of legislation already existing, already being processed or coming in the future, keep in mind that there is this horizontal framework, that there are not overlappings between those specific pieces of legislation and the horizontal framework that will be due diligence. And honestly, to keep the level of overregulation on specific sector as low as possible, and to do it only when necessary. Then, of course, we may find situations where new treaties or international conventions are adopted, so we need to keep the annexes a bit open via delegated act to make it future-proof. Review clauses will play an important role, particularly, for example, financial sector is not included in this directive now. We may have a review clause to include it in the future. The same for harmonization. There needs to be a review clause to assess in 5-6 years whether or not there is a need for further harmonization of the directive if we see that this is really creating differences in between the different countries. And then the Commission guidelines. We have been very strict by requesting mandatory, to oblige the Commission to come up with guidelines so that companies, and particularly SMEs that will be indirectly impacted by the directive, can have as much information as possible and as much legal certainty as possible to comply with their duties. And I think I have consumed my time, so I will not get any more. And yeah, thank you for having me.
No, Jorge, thank you very much. Very appreciated. I'm sure there will be some questions following this, maybe from the other panelists, maybe from the audience. Evan.
Thank you, and good afternoon. Thanks for inviting me to join. Evan Williams from the U.S. Chamber of Commerce. I sit in our Center for Capital Markets Competitiveness, and I have conversations with businesses beyond the financial services sector on a daily basis about their corporate governance, about their company practices, and how they can be responsible actors in the marketplace. So I just want to start by saying, one, I really appreciate the work that you all have done on this particular paper to vocalize some of the concerns of businesses, and to say that, you know, the chamber from a larger position perspective agrees in principle with the goal of the CSDDD, but you know, worry that businesses do not have the capacity to be to play the role of government in the global context. So a couple of things here I just want to briefly touch on. The first of which is, this is not just a financial services regulation. There's been a lot of, I think, ink spilled about the inclusion versus not of the financial services sector, but that's only one facet of this directive, of this proposed directive. And as a matter of fact, the Spanish presidency just sort of released a position of its own to say that they think that the financial services sector should be scoped out of the final text, and that a clause should be added to revisit that evaluation later, which I think is a reasonable compromise in an approach to trying to mitigate some of the risks about fragmentation that Jorge has identified, some of the concerns that Tsvetelina identified, in a reasonable way. But we are really concerned from an American business perspective about the effects that this directive would have on, one, our jurisdictional law, but two, the way that our companies interact. It almost feels, to a certain degree, with the inclusion of things like the direct private right of action to directors, right, that you're setting companies up to fail. And Jorge did a good job, I thought, of discussing ways in which you might be able to mitigate some of the litigation risk resulting. But let me offer a perspective here from our own exercise on legislation. You all have rightfully brought up the Uyghur Forced Labor Act here in the United States. In the initial stages of that legislation, of which I was involved in the negotiation, there was an idea to require companies to disclose the degree to which they had an interaction with or potential interaction with Uyghur forced labor in the Xinjiang province. And as we had conversations with our membership, big multinational companies who do business in, every jurisdiction around the world came to us and said, we don't have the supply chain mapping that would be needed to actually perform the kinds of analysis that that a disclosure of this kind, that a securities disclosure particularly of this kind would require, right? So we don't have the visibility down into our supply chain and into, the deeper parts of a value chain that would really produce a proper analysis of whether or not we have an interaction with Uyghur forced labor. And I bring this example up not to say that we disagree with the spirit of what this of trying to end interactions with Uyghur forced labor, but rather to say that there are reasonable expectations of businesses and there are unreasonable expectations of businesses, and opening them up to litigation on unreasonable expectations is a serious risk for global competitiveness, and something that we work very hard to try to avoid. I also I think that the points that you all have made about litigation risk are real, and it's not just litigation risk resulting from this directive in Europe. It's also litigation risk resulting from this directive in the United States, which has a far more litigious legal system than the European system is. And so we've really been encouraging members of the co-legislators to have more of a perspective on the impact extraterritorially for European companies than even just ex-EU companies who are operating in Europe. And then lastly, I really do want to underscore, emphasize, underline, highlight the concerns raised about relationship risks as a result of legislation of this kind. There was a mention earlier about the California effect, and a reference, I think Tsvetelina referenced the California laws that would require disclosure. So the difference, I think, in kind of principle in the California approach versus the European approach on something like reporting requirements is that California right away in both pieces of its legislation that just were finalized into law contemplates equivalency. So if you are a European company operating in the United States with multiple subsidiaries that trigger the requirements in California for disclosure, California gives you the opportunity to disclose at the parent company level for those subsidiaries, and will accept the reporting of another jurisdiction to satisfy its own reporting requirements. So if you're a European company operating in the United States and you're subject to CSRD, you report to CSRD, that satisfies the California requirements right away. There is not an inverse reverse consideration from the European Union on the CSRD. Now, we know that questions of equivalency are political in nature, and that the Commission has the right and responsibility to negotiate equivalency, partial equivalency, substituted compliance, etc. But it's sort of there's a difference, right, in the reach, in that one jurisdiction is full steam ahead, heads down, don't care what the impacts are necessarily for others, versus a more, I think, thoughtful approach that says, hey, look, we're going to have problems with international harmonization. Here's a way to solve it. And so, we are increasingly finding ourselves in a situation where the extraterritorial reach of European directives, including things like the Remit Act, right, are building up into a larger picture that has actually prompted members of Congress to write letters and ask questions on this subject, but also for Treasury Secretary Janet Yellen to make a public statement that says that that she's very concerned about the unintended consequences of the CSDDD. And that is a remarkable statement from a US official who probably in principle agrees with the direction of travel, philosophically agrees with the direction of travel in the European Union, but expresses concern about, sort of the building requirements of the Brussels effect and their impact on US multinational companies who really value their presence in the European market.
Very well, thank you, Evan. Look, I was trying to remember where I heard this expression about directional travel, and it's a. I'm sorry to say this. This made Michael is already nervous about what is this guy gonna say, but what I'm gonna say is that this is an expression that I remember it now from when I was young. Only it was a fellow traveler expression that was used, and had a very specific meaning. Look, what I wanted to say is that it was very interesting to hear the conversation, because Jorge and Evan, to a large degree, practical people, they have, one has the legislation to pass, the other guy got a whole bunch of businesses on his back. So they're looking how to make this stuff work in some way. Okay, they accept the direction of travel, and how they. I think Tsvetelina and myself, we couldn't resist dabble into the direction of travel, and whether philosophically, where this is going the right way or not. And it was maybe not a great part of your or my intervention, but certainly it was part of it. I think that again, the discussion will take place at different levels. One of them is where this is going in general, what the consequences and the long-term societal consequences of this, which it has societal consequences. Don't kid yourself. Every little stone in the dam will hold the dam or will make it collapse. But then you get into the Jorge and Evan show, whereby they're really concerned more about, what are the practical, if they take this, that this is going to go ahead, and how do you make this work? I'm a think tank, and therefore I'm preoccupied with other things now as well. Now, I will open it to the panelists. If you want to react to each of you, what have said, including Michael, including Anna, which is there somewhere, and but also to the people that are in the audience. We'll ask you very kindly to raise your hand, and then I'll promote you to a speaker, such a way that you can make your point, again, hopefully a short point, but with a question of some sort. Now, waiting for somebody to get the courage up, Michael or Tsvetelina or Jorge, do you guys have anything to comment on the other people's comments? Please go ahead. Tsvetelina, I think you're nodding, and I think that probably you do have something to say.
I can start, Tsvetelina, if it helps. And of course, I'll stop the moment that we see anybody raise their hand, since there isn't much time. So I'll echo Andre. I mean, these were terrific inputs from all three panelists. I learned a lot. It also reminded me of stuff that I'd read somewhere in all the documents and had forgotten or not included in my part of the presentation, and which deserve being back in there. Quick reactions, and again, keeping an eye out if there's any questions from the audience. But Tsvetelina, I agree, of course, and the word direction of travel is a nice word, that this is not, and I think I tried to indicate that this is something that's happening at the national level, happening in many sectors, and more broadly, the European Green Deal, but also what's happening in other countries in the world is echoing that. But at the same time, I think broadly speaking, corporate supply chains with suppliers in very complex international value chains, going all the way down to tiny enterprises in villages and in developing countries, etc., is not comparable to, say, banks and thinking about financial stability. And I think that we acknowledge that. I mean, I think we all agree on that. And that's precisely why Jorge was saying, we have to try and become clearer on the exact obligations, make sure that delegated or implementing guidance that comes subsequently narrows sort of legal uncertainty, and also potentially narrow a little bit the liability that could have a chilling effect. Not because we want to prevent the bad actors, but we also don't want to make everybody so nervous that it really then cuts off entire countries maybe from access to markets that they depend on. Thanks, Jorge, for reminding of the Regulatory Scrutiny Board. I thought that was quite remarkable. I remember seeing that, and that it took sort of this veto to get past that, the better regulation sort of threshold there. And thanks for pointing out those missed opportunities, points that we should include in the paper. And finally, Evan, we're thinking about similar issues you raised about reciprocity and trying to give a little bit more flexibility in how actors in different jurisdictions meet commitments in the context of, for instance, CBAM or this US-Europe global arrangement on sustainable steel and aluminum. They cannot agree on one jurisdiction giving up its monitoring, reporting, and verification frameworks in favor of something common, because each jurisdiction is so deeply entrenched, there's no way that we're going to see harmonization. I think we need to think about these things that are perhaps smarter and more flexible approaches to just say it's good enough. It's not our approach. It's not 100% the same thing we do, but it is something that if California considers it sufficient, we in Europe should respect that as well, which goes right back to the philosophical things Andre mentioned about sort of national determination as well. And finally, I'm very happy that Janet Yellen has also expressed concern. Makes me feel that I can hide behind her broad presence.
Well, you can always
in an intellectual sense.
You can always quote Janet Yellen now, and if anybody go argue with Janet. Tsvetelina, do you want to come back? I'm not pressing you. I don't see any hands. Okay, with very little time, but I was really hoping that some of them will intervene. People seem to be shy if they're not in the room. It's understandable but regrettable. Anyone else? Anyone wants to add something? Well, great. Yeah, Jorge.
No, I was not asking for the floor. I just wanted to, if I'm given the floor, I just wanted to, again, thank you all for organizing this event. And I have to say that I have also learned a lot from the other two speakers and from the study, the report you have prepared. So, let's keep on this kind of cooperation, including civil society and different voices, definitely.
Jorge, we have a winner. We have a person that has asked on the floor. There's a very brave person. So, Elke Roland, I don't know who she is, but I'll ask her to introduce herself. No, I think it may have been a false alarm. Oh, no, it is not a false alarm. Elke? Hello? You are muted. If you are intending to take the floor,
Can you hear me now?
Yes. If you can introduce yourself very briefly,
yeah.
Yes, please.
Yes, I'm Elke Roeland, based in Amsterdam with the American Chamber of Commerce in the Netherlands here. I would like to get from the panel some key message that we can take to our national government on this specific topic. What do you think is important to bring across? I would find that very helpful if you could help me with that. Thank you.
Well, there's an opportunity to influence the American Chamber in the Netherlands. I think Evan is probably the wheels are turning. Jorge, anything from your side that you would advise the American Chamber in the Netherlands or Tsvetelina? What would you tell them? I mean, what would you like them to say?
To the American Chamber in the Netherlands, first of all, I think the first advice when it comes to this file would be to really work and encourage European legislature and their European counterparts to fight for a common approach in the European Union, because many times for American companies, for non-EU companies in general, we already know that for them in many cases it's already complex enough to do businesses in Europe. The regulatory requirements are already maybe above what the US establishes for certain areas of activities. So the fact that we have this ambitious piece of legislation establishing new obligations will be already complicated enough when it comes to operating in Europe. So really the fact of having to comply with 27 different legislative framework would be, I think, very bad news for American investment in Europe. So what I mean, my advice would be to really advocate for a common European approach, so that given that it will be already difficult, to make it less difficult than having to respect 27 different frameworks, definitely.
Anyone else that wants to react to what Elke has mentioned? Anybody wants to give advice? Tsvetelina, you want to give them advice?
Maybe I can mention, maybe not so much of an advice, but to mention that Dutch politicians and the Dutch financial sector, as I mentioned, Dutch stakeholders have been very involved and proactive in that legislation. In fact, the European Parliament negotiator is a Dutch MEP. The ECB remarks a couple of days ago were in Brussels at the Dutch organized and Dutch-led event. And I did mention that the different industries in the Netherlands are taking a very proactive stance on this. So in this regard, maybe I can echo the position that for the moment, a lot is undecided, and we do see a lot of clashes between the different member states. The Parliament and the Commission already have their positions and are negotiating within the Council, but we do see very clashing positions coming from the different member states. So yeah, a common approach to eventually push this over before the European elections kick in. I think from a purely legislative perspective, and just coming to a common, in a typical Brussels decision-making process, coming to a common conclusion and a compromise would be essential.
Evan, this is like a last round, last tour around. Go ahead.
Sure. I'll incorporate my concluding remarks here as well. I think the advice of the other two panelists is valuable, and I've got good news for you. We have our own position paper on this subject that lays out pretty clearly what the priorities for U.S. business are in the context of this file. So I'm hopeful that in the next day or two, Elke, you'll hear from our Europe team sharing out that paper with you. I just want to say thank you to Tsvetelina and Jorge. This is, these kinds of dialogues are so important, and to have the sort of various perspectives represented is valuable, because it does help to think beyond the practical, and to think about the world as it should be is a really powerful thing. And we need that kind of big thinking. We need that kind of push And I'm just grateful to have had an opportunity to participate and to talk about the practical, the pragmatic, but also to talk about the normative and the way that the world should be. So thanks.
Michael,
No, after that, I can't add anything.
no, look, thanks to Anna and to Michael for working together. They put most of the effort. But I think that again, since we are a think tank, I think that you have to think globally and long term, whether to call it direction of travel or something else, as to where that takes you. You do have to think that way, because every little bit counts and everything is added to one on top of the other. So, but there's also the reality, the cruel reality of the daylight, that we are faced with a piece of legislation. And whether you agree with the direction of travel or not, that piece of there are provisions in there that are important, and they should be looked at carefully. I think that some of them have been mentioned. What are the breadth of of who has access to this kind of tools, and that's not an important thing. I mean, you could end up with a with a very litigious kind of situation all over the world. There are a number of other things that have been mentioned in terms of the obligations of companies to deal with certain treaty obligations. But in principle, I think we are heading off towards a trialogue, and we will continue to follow this file. We'll try to contribute as much as we can. Jorge, Tsvetelina, Evan, thank you very much for taking the time. Again, happy that there was a little contribution from our side to making this better. And we will issue now we have learned a bit more. We'll probably issue the report by Monday or so, because there will be a few things that we want to correct there again. But thanks a lot for the time, and thank all those that have taken the time to listen to us. Hi, have a nice rest of the day. Thank you.
Thank you.
Bye-bye.